Could be. Well, we'll know by the first fucking question. It won't be coming from these two. Yes, it is. Case, man.
Here.
Judges of the court, all please rise. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in it for the State of New York, we now draw near, give their attendance, and they will be heard. All please be seated.
Good afternoon, everyone. This is number 131 on the calendar, matter of Morgan versus de Blasio. Counsel?
Thank you, Your Honor. Chief Justice, Your Honors, may it please the Court. My name is James Walsh, and I'm here representing Mr. Lauder and the other individuals who have, I misspoke. Your Honor, I apologize. I'm here in this action representing Mr. Morgan and the other individuals that have brought this action below. We brought it in Richmond County. And in Richmond County, Your Honors, we brought the action specifically because there was a...
Counsel, may I interrupt you for a moment? Would you like some rebuttal time?
I would like to reserve some rebuttal time, if I may. Can I have
2 minutes?
2 minutes? Your Honor, specifically, there was a failure within the authorization of Mr. de Blasio. The authorization pursuant to the statute 6120, subparagraph 3, the authorization needs to be made by the executive committees of the 5 counties in the 5 boroughs that make up the city of New York, that when those executive committees meet, those executive committees, using weighted vote from the last gubernatorial election, designate who the candidate will be. And that's what Section 6-120 subparagraph 3 is. We don't have that type of authorization. The City Board of Elections should have thrown this out on its face because the statute, the authorization fails to comply with the statute, but they didn't. They had 5 members who ruled to throw it out, 2 members abstaining, and a couple of members ruling to make it valid.
Counselor, would you address what you believe the rule is or should be in terms of when the party has to be served?
Your Honor, the issue that is who is a party that has an interest and whose rights would be affected and whose rights would be affected, and I want to say equitably, whose equitable rights would be affected.
So if a candidate is either kept on or kept off a party's line, does that equitably affect the party in your view?
No, Your Honor, it doesn't. And I say it doesn't because the candidate is the individual who is at interest whether or not they're going to appear on the party line.
But doesn't the party have an interest in having a candidate on its line?
If the party properly followed the law, I would say yes, they would have an interest. And if the party properly followed the law and followed 6-120, subparagraph 3, then if I was objecting to it, then I would have had to sue all of those county committees. And I would have had to sue the county committee of the Working Families Party because they do then have an interest. But when they fail to follow the law, they can't come saying, equitably, we got to protect our rights.
But if they'd follow the law, you'd have no suit.
If they followed the law, I'd have no suit. Yes, Your Honor.
So you're really saying because you win, because you should win, you don't have to sue them. But that you're putting the cart before the horse, no?
Well, Your Honor, I shouldn't have to sue them because this New York City Board of Elections should have on its face found it invalid for failure to comply with 6-120. But the board didn't. There was a split ruling, and the ruling went 5 votes to invalidate it, 2 abstentions, and I think 3 to say it was okay. So the board on its own should have looked at it and said, it doesn't comply with the law, we're not accepting this. So the prima facie review.
Are there practical consequences for a political party, whether it has a candidate on the ballot or not?
Your Honor, I would say that there are practical consequences whether a party is there. But in order to protect your rights as a party, you would have had to follow the law in the first place. I can't serve a proper suit against the New York City Working Families Party for the 5 boroughs because they don't exist.
So whose action are you challenging here, counsel?
Your Honor, I don't think that the board should have authorized the candidacy. I don't think that there should be a Working Families Party candidate for the mayor of the city of New York. Nor, I really am complaining also of the actions of the board. The board should have invalidated this on this face, but without the board's action, I had to preserve my rights. And the way I preserve my rights is I go in pursuant to the election law 16-102, and I bring an action with either a candidate, a party chairman, or with the objectors. I have 2 objectors, the parties, the named members of this case. They objected pursuant to 16-102. They did so timely. They brought their objections before saying, listen, for an authorization, you need the authorization, you need the acceptance, and you need the petitions. You have to have all 3, and all 3 need to be legal in order to get on the ballot. And without all 3, it's a 3-legged stool. Remove one of the legs, and it fails.
Are you challenging the action of the state executive board?
I'm not challenging their actions, Your Honor. I'm saying that it's a nullity. It's a legal nullity. It doesn't exist because they didn't follow the statute. The statute says 6-120 sub 3 says it's the 5 committees within the city, the executive committees within the city of New York. So I'm not objecting to their actions, and nor am I objecting to the rules, despite what my learned adversary says. I'm not objecting to the rules because their rules, I did not have an Independence Party member file an objection against their rules. Their rules can be whatever they would like their rules to be. But when it comes down to the rules versus the law, they have an obligation to follow the law.
Well, getting back to Judge Wilson's question, you say their actions were a nullity. So it is their actions that are in question. Their actions are doing something that you say violates the law. What if they have a legal hypothetically, if they have a legal argument as to, well, no, we really didn't violate the law because, and they interpreted some, some case law or something else, or they had a novel argument, legal argument, that in fact what they did was perfectly okay, but they didn't get served. How could they make that argument?
Well, Your Honor, I couldn't serve the 5 executive committees of the Working Family Party in the city of New York.
Because there are none.
They don't exist.
Yeah, we're talking about the state.
The state executive party, if what they did had the color of law, Your Honor, I would agree that I would have had to serve them.
But who decides whether it has color of law? You're making that determination? Isn't that what the court is ultimately for when you challenge their action of designating or nominating this candidate?
I think the legislature did that, Your Honor. It's not up to me. The legislature did that when they established 6-120 sub 3.
But if there was a legal argument that said that statute didn't control, that there was some exception or there was some interpretation somewhere in the law that called that into question in these circumstances, without serving the state executive board, they would never be entitled to come in and make their argument. So isn't that what the purpose of service is?
Well, Your Honor, I would say that only if it was just. Your Honor, that there's an inequity going on here. That they can't not follow 6-120 and then expect their rights to be protected. The 6-120 doesn't give them that authority to file the certificate. They could be brought up on charges for filing a false instrument.
You know, it's just not, though, for the purpose of their rights being protected. It's the purpose of all the litigants and also for the court to have everybody in front of us so we can hear their arguments. That's why we put them on notice.
Yes, Your Honor.
You see what I'm saying?
I understand exactly what you're saying, Your Honor, but the Working Family Party, if the state Working Families Party was allowed to designate who the candidates in New York City would be, then New York City Working Family Party's members wouldn't be allowed to follow the rules. My position here would be that you're only a necessary party if you follow the law. I understand I'm out of time, but my submission would be that you only get to apply and come to this court asking for equitable relief to be included if you've got clean hands. And when you don't have clean hands, when you put it forth a certificate that's unclean, you don't get a second bite at the apple. Thank you, Your Honor.
Thank you. Counsel?
Good afternoon, Your Honors. I apologize to this court. I'm somewhat baffled. I believe there are 3 documents that have conferred this nomination on Bill de Blasio. There is an authorization, there is a petition, and there is an acceptance. Under the election law, it takes all 3 documents to confer such a nomination. They are all named parties. Bill de Blasio filed petitions. His name is on that petition. He was named as a respondent in the election law proceeding. Bill de Blasio signed an acceptance of the Working Families nomination because he's not an enrolled member of that party. He is a respondent in these proceedings. The secretary and chairperson of a party committee of the Working Families Party signed the initial document, the authorization. They are absent from this proceeding. As many of the questions coming from this bench indicate, they had a right to come into the courthouse and say, here is why our rules are in fact compliance with 6-120 and maybe the cases decided by this court in prior years. They were not given that opportunity. And parenthetically,
where are they located and how can they be served?
I'm sorry?
Where are they located and how can they be served?
They're located in the state of New York. There's an address. It's not a hidden, process. They are in fact registered with the Board of Elections as a party because they had to submit their rules to the Board of Elections as a matter of another provision of the election law. So their address and contact information is there.
Is this particular process that they engaged in this case, is that in their written rules?
Yes, it is. Absolutely. As I indicated during my leave argument, Your Honor, I want to digress only momentarily because this is where my real abject confusion lies in part, and I must point this out to the entire bench. On the trial level, Supreme Court, Richmond County, which for independent reasons we've made clear in our briefs we shouldn't have been in that county, but putting that aside, the court dismissed the application made by my colleague for two reasons. One, the failure to join a necessary party, which is what we are arguing before this court at the moment, but also they failed to comply with 6-154 of the election law in timely filing general objections against this document, this authorization that is being argued here right now. The Board of Elections found that to be a late document as set forth in their ledger. Judge in Richmond County found it late and therefore dismissed on those grounds. And at the Appellate Division, Second Department, the court reached a conclusion that we do not have to reach this other issue because we reached the issue solely on the failure to join a necessary party. So in all possible circumstances, if we were not to prevail on behalf of Mr. de Blasio here today, at minimum, this case should be remanded back to the Second Department for a ruling on the other grounds which we sustained at the trial level, dismissing the objections and dismissing the initial proceeding. Putting that aside, Your Honor, I believe the cases that are cited by counsel are distinguishable from the cases cited by the Second Department. We urge this court to affirm the decision below for the reasons stated.
I'm sorry, counsel, before you go, sure. How would you distinguish those cases? On what
Certainly. Case cited by counsel, in particular the O'Brien-Chrysler case from the Fourth Department. That was not a case about party rules. The party rules were clear and unequivocal. The party in that circumstance could confer a nomination on a town position by caucus of that party. And for a county position, they could not effectuate that kind of a nomination. Here, the fight was whether the position in question was a town or county position. The trial court said, I'm going to have a hearing on the entire matter, and I'm also going to dismiss, however, on the failure to include join a necessary party. When it got to the appellate division and the decision was 3-2, on that issue and that issue alone, it wasn't a challenge to the rules of the party. It was a challenge to the application of those rules.
So it's only a necessary party if you're challenging the rules of the party?
Or the internal workings of the party. It is action, authority.
But why then isn't the dissent right in that case, saying that by seeking and proceeding to void the certificate of nominations, petitioner necessarily challenged the propriety of the nominating caucus? Why isn't that equitably affecting the party then?
Well, I believe it did. I would subscribe to the dissent, as I said during my
They're not distinguishable, they just got it wrong.
Yeah. Maybe that's a better way to express it, Your Honor. I thank you. Thank you all.
Thank you. Counsel, any rebuttal?
Briefly, thank you, Your Honors. The party rules can't trump the election law. Your party can make any rules it would like to do, but generally speaking, the election law is going to overrule any party rules. Many party rules would incorporate Robert's Rules of Order into them, but the election law is going to trump Robert's rules. It's going to trump the party rules. So that would be my first point. I have not objected to the rules of the Working Families Party. For me to properly do that, there would have had to been a person of that party who filed an objection to the workings of that party. I'm not going behind and objecting to the rules. What I'm saying is that in order to have a good acceptance, you need to have a valid authorization. You need to have a valid number of signatures to gain access to the petition. Without any one of the three, your whole table falls, and that without a valid authorization, the acceptance is invalid because the acceptance is a nullity, or the authorization is a nullity. When I object, I have timely objected to the acceptance, and you cannot accept a authorization that's fatally flawed and is invalid on its face. Thank you, Your Honors.
Thank you, counsel.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in it for the State of New York, may depart hence and appear here at the next scheduled session of this court, to which time this court now stands adjourned, unless sooner convened by the Chief Judge or the Senior Associate Judge present in the State.